When you're buying a property subject to, which is the best way to take title? A trust or an LLC? And which is better at keeping the due on sale police away and protecting you in a bunch of other ways? That's what we're talking about today on the Sub2Deals Show. Hey guys, welcome to this episode of the Sub2Deals Show, where we talk about all things subject to. Occasionally, we talk about other real estate investing topics as well, but it's usually something to help you with your real estate investing business. Today, we're talking about LLCs and trusts, or land trust, as a lot of people refer to them, and which is the best way to take title, especially when you buy a property subject to. Well, let me start by saying that this was prompted by, hanging out in a bunch of groups and hearing a lot of professionals talk about what is best and why. And if you hang out in any number of these creative finance groups, you'll see literally thousands of experts telling you how to handle the due on sale clause that's in pretty much every mortgage out there right now. But really, the funny thing about all of it is that most of these experts have never even completed a single real estate transaction. And that's pretty common in what we do. And it may be common everywhere. I don't know. I don't spend a lot of time in other types of groups. So I'm not familiar with how they operate. I've pretty much stuck to real estate for the last 25 years and spent all of my time. My wife gets on me all the time. She says, you need a hobby. And I said, listen, real estate is my hobby. It's what I like. I love doing it. It's not like work. And they say when, you enjoy what you do, you never have to go to work. And that's really how I feel about it. But so maybe it's common in all industries that experts, armchair quarterbacks, people that don't really play the game, but they know 6 ways from Sunday on how to do it. I mean, I've had students like that before in my groups that knew every way to take down a deal, but had never done it personally for one reason or another. They were afraid or some kind of fear kept them from it. But a lot of these experts that are telling you exactly what you need to do have never completed a real estate transaction. Now, they have done a lot of studying in Facebook groups and learned from other experts or YouTube videos, and there's a lot of good information on YouTube. The problem is you just don't really know. If you don't know the teacher, you don't really know if they know much about what they're talking about. But really, is there a best way? And I got to tell you, before I learned about land trust and things like that, the first few houses I bought, man, I bought them in my name. That's how little I knew. And, nothing bad happened to me. And chances are nothing bad will happen to you either. But if you can go in educated, it's always better. And so that's why we're going to talk about that today. So let's talk about some facts and look at a few things. And as with everything that we talk about here, your situation may be different. Everybody's situation is different. People want to ask you about taxes, entity structures, things like that. And a lot of those things vary depending on the individual. So I don't know your particular circumstances. So I'm just going to speak from my experience and how things work for me. So let's talk first about what a land trust is, what an LLC is, and the differences in those two. Now, a land trust is a legal entity that takes ownership of or authority over a piece of property at the request of the property owner. Land trusts are living trusts that allow for the management of the property while the owner is alive. A limited liability company, or an LLC, is a business structure that combines elements of a corporation and a partnership. It relieves its owners of personal responsibility for the company's debts and liabilities, while also allowing them to avoid the double taxation often associated with corporations. Now, that's the technical part of what they are and the differences between them. Now, we need to understand what a land trust and LLC are, and I've just explained that. So let's get back to answering the question of which one is best for helping you avoid a due on sale problem. Before we do that, if you guys find value in our videos, you like our channel, I'd just like to ask you a quick favor. hit the subscribe button, the notification bell, and you'll be notified when we release some new videos. Okay. So if you do that, I'd really appreciate it and help us out. So which is better? First, the use of a trust or land trust, and understand we're talking about subject to here today, but every house that I've bought since I learned about a trust, I have titled in a trust. If I'm keeping it more than a couple of minutes, it goes into a trust. And the use of a trust or a land trust, if that's what you like to call it, it does not automatically prevent a lender from calling a loan due or give you 100% protection from this happening. That is a common misconception. I see this all the time. Put your house in a trust, leave the seller a 1% beneficial interest in the trust, and you will not have a due on sale issue. And this is absolutely not true. If you read a due on sale clause carefully, it says transfer of any interest at all. And really what that means is if you only had a 1% interest, if the seller put their property in a trust and only gave you 1% and they kept 99%, technically the lender could still call that loan due because the owner had transferred an interest in that property. Okay, so it's important to understand that. Listen, guys, I'm not a lawyer, but I stand by my statement on this being a fact. Okay, using a trust is not going to protect you 100% from a due on sale violation. Now, it will help you in a lot of other ways, and the lender will not automatically call a loan due just because title's transferred to an LLC. Now, a lot of people don't know this. I don't see this talked about a bunch in groups. In fact, I saw a video recently where an attorney that's supposed to be an expert on YouTube said that she advises her clients not to transfer their own property into an LLC because a loan can be called due. But in 2017, both Fannie Mae and Freddie Mac adopted language allowing for the borrower on a loan to transfer their property out of their name and into an LLC without it being a due on sale violation. So if you own that property and the mortgage is in your name and you want to transfer it into an LLC for asset protection or whatever your case may be, some degree of privacy, you can do that without fear of having your loan called due. If you're buying a house subject to and your seller deeds the property into your LLC, that's a due on sale violation. Again, it doesn't mean the loan will be called due. It just means it is a due on sale violation. Now, a lender will not call a loan due just because you transfer title to an LLC, and they will not fail to call it due just because you transfer title to a trust. In order for the lender to even consider calling the loan due, they would have to actually see that title has been transferred in the first place. And this is really highly unlikely in almost any case, unless they're out randomly checking title or someone tells them about the sale in detail. And otherwise, the lender is highly unlikely to ever know anything about the title change. And really, the only way they'll ever know anything, and I've talked about this before, is when they get the new insurance policy that you're going to get showing a new primary loss payee. That's going to be the only tip that they get that anything's happened. And if you handle that properly, and I know we've talked about that before, if you make your payments on time, you handle the insurance change properly, you're probably not going to have a problem. Okay, and if you guys want to learn more about insurance, you can check out our video. And you guys already know I'm not very technical. Something's going to pop up somewhere, probably over here somewhere, that's going to give you a link to an insurance video where we go into detail about how to handle insurance on your sub-twos. And that's really important. That's really one of the key things, as far as I'm concerned, in 25 years of doing this, handling your insurance properly and making sure you make the payments on time. Don't give them any reason to take a closer look at that thing, okay? Now, second, just because you place property in a trust does not mean the lender can't still call the loan due. The reason lenders can't call loans due when title is transferred to a trust is because holding title in a trust is one of the exceptions of the Garden-St. Germain Act that says a lender cannot call a loan due if a property is transferred into a trust for estate planning purposes. That's not there for investors to buy it. It's if the homeowner wants to transfer the property into a trust for estate planning. Okay, and that's obviously not what we're doing when we buy subject to and we place a property in a trust. We're using that loophole, not to mention the fact that holding your property in a trust is a great thing. It is just by itself. But we're using that loophole, and most of the time the lender makes the assumption that that's what's happening. Now, technically, land trusts are not always considered or used for estate planning trust. And if you, as the investor, are not the borrower on the loan, this means that the trust wasn't formed for estate planning purposes. And if the lender discovers this fact, they may not like it. And according to the terms of almost every due on sale clause that I've ever seen, they may or may not, at their discretion, call the loan due. Most don't care. Can they do it? You bet they can. And I'll tell you, in our current environment right now, with so much attention on subject twos, I think it may be more likely for them to start calling loans due. But if you read a due on sale clause, it's very specific in there, and it actually uses those words. The lender may, at their option, call the loan due. That doesn't really sound like they're drawing a line in the sand. Okay, it just says it's their option. They can do it if they want to. But chances are, again, just based on my experience, they really don't care. But you never know, and you need to understand that it is a very real possibility that they can do it. Now, for this reason, know that your use of a trust to take title to a property is not some foolproof 100% protection against a due on sale issue, regardless of what the experts in those Facebook groups may tell you. And third in this is use of an option does not in any way give you any asset protection beyond the anonymity that a trust offers. So a trust is not asset protection. Okay. Now, the use of a trust with your LLC as the beneficial interest, to me, that's the perfect way to hold title for so many reasons. When we buy subject to, we take over payments on a loan. Title goes from our seller to our trust. The loan doesn't get paid off. And when anybody goes snooping around at the courthouse for any reason, whether they're planning on suing someone or whatever may take place, all they're going to see is that Bob transferred his house to a trust. The loan didn't get paid off. There's no new financing. And what would that look like to most people that don't know as much about what's going on as you do? It's going to look like Bob just transferred his house into a trust for estate planning purposes. Us as investors are never associated with that house, not as a loan, not as an owner in any way. So there's really no way anyone could ever find out that you have anything to do with that property. And that's super cool. So if anyone tells you that if you take title a specific way, that you're 100% going to be safe from a lender calling the loan due, they're just wrong. There's just no way that we can 100% prevent the possibility of that happening. Now, again, what are the chances of it happening? In my experience, not very great. I've done this for 25 years. I've never had a loan call due. Could I have one call due tomorrow? You bet it could happen. Trusts are great for so many reasons, and they can be an additional layer of protection, but there are by no means a guarantee in this kind of situation. No means at all. So what's the bottom line here? Well, in my opinion, again, based on my experience and hours and hours and hours of discussion with attorneys, investors more experienced than me, using a trust to prevent a due on sale problem is superior than taking title in an LLC, but really only slightly so. With the 2017 Fannie Mae ruling, where you can place property in an LLC without triggering a due on sale clause, you're probably okay that way too, but a trust is slightly superior. So all this to say, buy property subject to based on your own tolerance for risk. Okay. The loan being called due is a real risk in a sub-2 deal. And if that possibility keeps you awake at night, or you don't have the things in place you need to deal with it happening, cash in the bank, access to cash, really good credit so you can refinance, you probably shouldn't be doing sub-2 deals. But I think they're great. I think anybody should be using them. But again, it's up to you and your tolerance for risk. So hope that helps, guys. So, the final analysis is a trust better than an LLC? In my opinion, yes. But not tremendously so. A combination of a trust with an LLC as your beneficial interest of that trust is going to give you the ultimate in asset protection and in privacy. So hope that helps. Anyway, if you guys have any suggestions for topics that you would like to hear on future podcasts, let us know below, and let us know in the comments. Are you guys using trust? Do you use LLCs to take title to your property? Do you take title to your property in your own name? Because I'm going to tell you, I've known investors over the years that own hundreds and hundreds of properties all in their name. Is it a good idea? I don't think so, but it works for some people. So know what the risks are in what you're doing, but don't spend too much time analyzing it, or don't let it keep you from going out and making a difference, making a change, and grabbing financial freedom. Don't, bad things can happen to you no matter what you do. There are a million stories out there about that. So people that think they're using the top shelf asset protection and thought they crossed every T and dotted every I, and they still got in trouble anyway. So evaluate things, make a decision, and move forward. Hope this helps. Hope you guys are having a great week out there, and get out there, talk to some sellers, buy some houses.